My name is Tim Lockhart, and I'm a lawyer here at Tannahill, Lockhart and Clark. I work with my father here. He's a partner at Tannahill, Lockhart and Clark. His name is John Lockhart. The first topic that we're going to deal with today is what do you do when a person dies without a will?
The legislation in Ontario sets out who may apply to be an estate trustee when there is no will. The legislation also sets out who gets the assets of the estate when there is no will. Generally, it's next of kin that can apply for to be appointed the estate trustee, and also the people that get the assets of the estate.
And the estate trustee is also referred to often as an executor, especially within a will. When this process unfolds with a person who doesn't have a will, who passes away, there's this court application that John had mentioned that is required. But often we'll have cases where there's a dispute who should be appointed by the courts to take care of the assets of the estate. And because it's next of kin, you could have a situation where, for example, you have two children. They're both equally next of kin of the deceased. They both have the same right to be appointed, and this can cause serious conflict as well as serious problems and legal issues that need to be taken to court and have a judge address, which increases legal fees and results in a more expensive administration of the estate. So John, you spoke a little bit about who gets the assets when there's no will in an estate. We have a lot of clients that come to us and ask the question whether the government can take the assets of the estate because the person doesn't have a will. Almost always the answer is no. The assets do go to the next of kin, which is basically set out in the statute, going basically from your closest living relatives, and it spreads from there.
Now that we've discussed who can apply to be an estate trustee or an executor when there is no will, the logical question is, does it cost more money? And the simple answer is yes. If there is no will, the estate court will require that the estate trustee post a bond, which can be expensive. There is a procedure for applying for a court order to dispense with the bond, but that again involves extra legal fees. So the simple answer to the question, are there extra steps or expense required when you don't have a will? And the answer is yes.
I'd just also like to know that there are other more complicated steps that not necessarily the lawyer needs to take, but the executor does. And an example of this would be a notice to creditors that is required to be done. So not only is it more expensive and are there more steps, but it also takes a lot more time. A question that we're often given in terms of estates is whether gifts given in a will are taxable. And the answer inevitably is almost always yes. I mean, there's a common adage, the only guarantees in life are death and taxes. Well, they didn't talk about the death tax.
Tim, you've talked about a death tax, but it is fairly minimal. And the estate tax is 1.5%, unless you're dealing with a capital gain on a property that is not exempt. For instance, your personal residence is exempt, but if you had a rental property or you had a big stock market gain, then those gains would be taxable in the estate.
Often we're asked about specific assets, such as RRSPs. And so generally the estate does have to pay tax on the RRSP, but in these cases, you'll have, almost in all these cases, you'll have what's called a beneficiary to these RRSPs. The beneficiary is a person who receives the RRSP. The problem is that the estate is the person who's left with the tax bill. And so you could have a situation where, I'll give my brother my RRSP, and then I'll give my other brother my house. Well, one brother gets the RRSP, it's done, he can walk away. However, the brother who gets the house has to pay the tax bill on that RRSP, and that can be quite expensive. And so this is another good reason when you're doing estate planning to actually talk to a lawyer and deal with all these things, because it can be very complicated, but it also can lead to more and more expenses, and the beneficiary not really getting what they wanted, and the person who is giving these gifts, their wishes are not respected just by the way that the law operates and who has to pay the tax. On our website, we have frequently asked questions on this subject.